everyone. Welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are with the attorneys Prashanthi Reddy today to discuss the latest updates on Department of State exemptions published today, possible second round of the lottery of H-1B, updates on lawsuits and other immigration matters. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We will start taking calls in 20 minutes. Before that, I would like to repeat the disclaimer. Please note that the show is not intended to provide any legal advice, and it is very general in nature and only is for informational purposes. Sakshi TV, news, or agents are not responsible in any way for your actions. Use of information is at your own risk. So, hi Prashanthi Reddy garu, how are you doing?
Hello, Andy.
So yeah, a lot of things happened in the last week, and today in the morning, Department of State published a few exemptions. So I would like to talk to you before we get the call. So there are a lot of exceptions from Department of State that are published today. So do you want to give some updates to the callers, what happened and what are the exemptions, especially for the H-1B and other non-immigrant visas?
Yeah, so this is very fresh, and I haven't had a chance to actually read the entire document, but I can give you a summary of what it is. And then maybe the next show we can talk more in detail because this just came out. But basically, what it is, the most important part of it is that basically if you are going back on a H1 and you've already been on a H1, you're going back to join the same employer and the same job. So basically in your I-129, if you marked extension without change, so that automatically qualifies for an exemption. But what's happening in these situations is that they're going to still decide on a case-by-case basis. So you still have to approach the consulate, tell them that you qualify for an exemption, and most probably give them a write-up or ask your attorney to provide a write-up as to how you qualify for any of these particular exemptions. So the first one, so what you need to do is, if it's an emergency, you can of course apply for an emergency visa. And then if you think that you qualify for an exemption, then you have to state specifically, and then the Department of State has to agree that it's an exemption, then they'll give you a visa, otherwise they'll deny the visa. So very important, these two things. First, get an appointment. Second, once you get the appointment, show them how you are exempt or how you qualify for the visa despite the presidential proclamation. So the first way that I was just saying is, if you are going back to the same employer, same job, nothing has changed, then apparently it is an exemption. So you have to, based on that, you have to send a write-up and tell the consular officer that. Second is, if your travel is required, even if it's not, suppose you filed a transfer and you went out of the country to get, because your visa expired, and to get a fresh visa, a visa extension or revalidation as they call it, you could still qualify provided that your travel is supported by a request from a US government or entity. So if your H1 was filed either directly, or if your end client even, I'm thinking, is a US government or research organization or defense, then you could still be exempt. If it is considered to be essential for you to come back, essential by the government for you to come back. This is nothing related to COVID, so it doesn't have to be related to the other exemptions. We already have other exemptions. If you're working in healthcare or some other sector where it's related to COVID or COVID recovery, then you can always come back. That is a previous exemption that was already in place. This is not related to COVID. It's just that these services should be considered essential by the government. That's all.
Sorry to interrupt you, Prashanthi garu. We have a caller. I think let's take a caller and then we can resume. Hi, can you hear me?
Yes.
Yeah. Prashanthi Reddy garu is here, and you can ask your question and she'll answer the question.
Hello. Hi, Prashanthi Reddy garu. My name is Ramke, and I'm calling from Dallas, Texas.
Yes, go
Can you
ahead.
hear
Please
me?
ask your question. Yes, I can hear you.
I did my PhD in microbiology in India. Then I came here as a postdoc. So I mean, we also work on the microbiology stuff, something related to healthcare. So now I would like to apply for the green card. I'm in H-1B. So can I? Do you have any suggestions for should I go for the EB1A or EB1 category or EB2 category or NIW?
So if you're a researcher,
Can you
then
suggest me
if your
in this
employer is
scenario?
willing to support you, if you're a researcher and your employer is willing to support you, file the I-140 petition, then you should apply for under the researcher category, EB1. It is national interest waiver is much more difficult. The standard is much higher. I would go with an easier standard because they're both EB1 with the same priority dates. So, always follow the easiest route. Go with the researcher category under EB1. Only thing is the I-140 has to be signed by the employer. And of course, you should still be working for that research organization. And your research should still be relevant, to healthcare or whatever the national interest of the United States.
Okay, thanks for your call, Ram. We have another caller, Sunny from California. Let's take the question from caller. Hi, Sunny. How are you doing?
Yeah, I'm doing good.
Yeah, you can ask your question and, attorney will answer.
Yeah. Hi, Prashanthi.
Hello.
Yeah. So basically, H-1B transfer, if we don't have an end client letter, if we do the H-1B transfer from company A to company B, in the premium processing, without the end client letter, is it going to show any impact?
So you need the end client letter to show that what your duties are and to show that the duties are, qualify you for a specialty occupation. You don't need the end client letter like previously to show right to control, but you still need it to show specialty occupation. So if you're able to show the duties from the client in some other way, like on their website or via email, then you can do that as well.
So right now the end client is not willing to provide the end client letter. So that is the reason. Implementation partner client letter they are willing to provide, and the vendor letter. Yeah, we only have these two documents, Prashanthi.
No, that's fine. It's not compulsory that you have to have the end client letter, and it's not compulsory that they should deny the case simply because the end client letter is not there. So end client letter is useful, but it's not absolutely necessary. There are other ways of showing what your duties are.
Okay, thanks for your question, Sunny. So yeah, as per recent, the lawsuit that was filed by one of the organizations, and USCIS probably came back saying that there is no employer-employee relationship that is needed and no client letters and itinerary requirement. So do you still think we need those documents, or is there any flexibility?
We don't need an itinerary, but everything else is needed. The client letter is needed, as I just stated, to show specialty occupation, not to show right to control. The contracts, is basically needed just to show that you have some work. It cannot be speculative. Your H-1B cannot be filed on a speculative basis. You have to show that you actually have work, and that is shown. The best way to show that is, through a purchase order and a contract. So for that purposes, it's needed, but it's not necessary that you have to show the contracts between every single party like it was earlier. But you still need to show some contracts at least between yourself and the vendor and the PO to show that you have a job.
Okay, got it. Okay, going back to our, the Department of State update on, non-immigrant visas. So I also see a section where it says, if the prevailing wage is over 15% of what it is, in which case, they are not harming American workers because they are not available for the job. So they are also exempt from this the presidential proclamation. So did you get a chance to look into that and see?
Yeah, so basically I was just going through all the exemptions, and maybe that will be better unless we get again interrupted by a caller. But basically, so one most important, most useful for people are that if you're going back to the same job with the same employer. The second that I mentioned again, just to recap, is if you're providing some kind of essential services for a government agency, and that could be anything. So try your luck. Don't think that it doesn't qualify.
Yeah, sorry to
and
interrupt
it could be
you.
in the IT sector.
Yeah. Sorry to interrupt you, Prashanthi. There is another caller, Sandhya from California. Let's take the call. Hi, Sandhya. Welcome to the show, and you can ask your question.
Hi. Hi. I have a question. So I got to travel to India in October. At the end of October, I recently changed my employer. It's a full-time job, but my visa stamping is with previous employer. So, and I don't know, is that okay to travel in October and come back safely? Or do you think I heard rumors that things might change after elections? Do you think it's going to be worse, or any other new immigration changes
in general, I don't think you should travel, because things keep changing every week. Unless it's an emergency, you shouldn't travel, because you don't know what will happen, as you rightly said. But do any of the presidential proclamations right now apply to you? No, they don't, because you are not out of the country when they were published, so you are not affected. But moving forward, we don't know. Suppose you go out of the country and some new proclamation comes, then you will be in trouble. So that's why better not to travel unless it's an emergency.
Yeah, it's a wedding. Actually, I already postponed one, so it's a second.
Unless it's your wedding. If it's
it's my wedding. It's my wedding.
Okay. So then it's an emergency.
I postponed it. So yeah, it's
right.
So basically, so there is two options. Like, one is like October, and if I postpone again, it's going to be December. Do you want me to push it to December? Or is it okay to take in October risk? What are the chances of getting better? I mean, things gets better in December if I move forward.
So your visa is you already have a visa. You don't need to go to the consulate, correct?
I don't have to go, because I have a visa with previous employer, not with current employer.
That doesn't matter.
I have visa till next.
That doesn't matter.
Okay,
you don't need a new visa. Yeah, you don't need a new visa.
Okay.
But first thing is, your health concerns. October is too close. We don't know what's going to happen, but flights may not be available. You have so many logistical problems. So if you have a wedding and you're not able to attend it due to these various reasons, I would just to be, more certain, I would postpone it to December, I think. If I was in your place, I would postpone it to December, because the more time you have, the more better decision that you can make.
Okay. Okay, good. Thank you.
You're welcome.
Yeah, thanks for your call, Sandhya. So yeah, going back to our discussion, sorry, we had an interruption. We had lots of callers. So yeah, so what are other exemptions that we have that you think can help people going back and coming into the country?
Right. So first is, of course, the public health exemption if you're working for COVID. Second is if you're working for a government agency. Third is if you're going back to resume your employment, because they say that they don't want the employers to look for someone new that could affect the economy as well and could affect employers. So they want that to be included. Third is senior level. If you're a senior level manager or worker and you're required to facilitate the continued economic recovery of the United States. So this is just economic recovery. It is very vague, the terminology. It's not COVID related again. So senior level manager. So under this category, again, it says, as you were saying with reference to the LCA, it says if your LCA was approved after July 2020, then it's likely that you can get approved under the senior level manager category. So anybody who has an LCA approved after July 2020. So we're taking away all the cap cases because they would have been before July. So post-cap, anybody who has filed and wants to, and who has got stuck outside the country for some reason, they could apply. Anybody under that position, senior level people, technical people who are working in infrastructure. So they're required to meet a critical infrastructure need in certain industries such as communication, defense, chemical, energy, financial services, food, agriculture. They've given a whole list of industries here. So if your employment is in a critical infrastructure sector, the consular officer might decide that you qualify for an exemption, provided that you're under a senior level placement. That is, you're not like some entry level person, but you're actually required in that role for the project to move forward. Or you have, certain specialized knowledge for the project. So under those two categories, if you're senior level and if you are working in a critical infrastructure position, then it's possible you could be exempt. Then the third possibility is, as you were saying, the wage rate. If your DOL wage rate is 15% above the prevailing wage rate, then it's possible that you could be exempt, because they're saying that you're getting paid above, the salary that is normally paid. So therefore, then your job will not affect, the other candidates. So that's how I guess they're kind of naming it. Then the fourth under this is H-1B applicants' education or training or experience demonstrates unusual expertise in a certain field. For example, a H-1B applicant with a doctorate or a PhD or many years of relevant experience may have such advanced expertise in a relevant occupation as to make it more likely that he or she will perform critically important work. There's so many exemptions here. You just have to very carefully look at your case. In fact, I think you should most probably have your case studied by an attorney to see if you fall under any of these exemptions. Have an attorney write a letter for you and submit that letter to the consulate. I think that would be the best thing to do. So that's one thing. And then for the H-1B, the last exemption is denial of the visa if it causes financial hardship to the US employer. This could be anything, because all denials will cause financial hardship, because they have to find a new person. They're giving an example. Who causes financial hardship for it? If a visa is denied, the employer's inability to meet financial or contractual obligations. This could be everybody, because most in the IT world, at least, most employers are being hire employees to meet a financial obligation or a contractual obligation. They already have a PO, they already have a contract. So I think most people would fall under this exemption. So this is another thing to keep in mind. So that is pretty much what we have with H-1Bs. Then there's H-2Bs, which we don't have to worry about. J-1s, pretty much the same exemptions. L-1s is again public health, healthcare professionals, US government agencies, same thing. To resume ongoing employment for the same employer, same thing again. Senior level managers.
Yeah, one question everyone has in mind is, anyways, the consulates are closed. Does this proclamation exemption mean that they will get emergency appointments, or they have exception in getting appointments, or is it just like you get to get an appointment only once the consulates are open? So this is kind of an open-ended question, but do you have any idea how this is going to work?
So the emergency is can be given. Again, you have to show that why it's an emergency and why your presence is required and what will happen if you don't go back. So that's one thing. Definitely emergency is one thing, but in order to get an emergency visa, first of all, you have to approach the consulate website. You have to send them an email requesting an emergency visa. You have to tell them what is your emergency. And based on that, it's possible that you can get an emergency visa. Otherwise, you just have to wait for the consulates to open up So as we have been saying all along, the presidential proclamations really don't have any effect until the consulates actually open up, because right now, even if there's no presidential proclamations, the consulates are still closed. So it's difficult to get a visa. But based on these same conditions that I just mentioned, especially working for government agencies, working for healthcare, working in research, perhaps a doctor, these people would definitely qualify for an emergency visa as well, in addition to an exception to the presidential proclamation. So it could be the same reasoning that you give for both, an emergency visa as well as an exception to the proclamation.
We have heard from few people in blogs and all that Delhi consulate is giving emergency appointments, if for the reason of family separation, like if H1 is stuck in India or H4 is stuck in India and the spouse is in US, or the kids or anyone who got separated. We are hearing a lot of news that Delhi consulate is giving emergency appointments for those. Do you have any idea, or did you come across anyone like that?
No, I've not heard that Delhi consulate is doing that, but it's good if they are. I know consulates in London are open for business. So, and slowly consulates in India are opening up also. They're just, since the COVID has hit India recently in the last few months, they're, I think, a little wary about opening up. So Hyderabad would be unlikely to open. Telangana will be unlikely to open up soon until the numbers actually go down. But like you said, Delhi is much better. Mumbai is unlikely to open up. So I think Delhi at this point is the best bet, because they are seeing a recovery with their COVID numbers, more so than Mumbai and Telangana. So yeah, I'm not surprised that you said that the Delhi consulate is giving more emergency visas. Another reason they could give emergency visas is also, one is, as you said, family separation, and that's, if they're doing that based on family separation, that's a good thing. But another reason is also due to aging out. So if the H4, there's a H4 person and he's becoming
sorry
21.
to interrupt you, Prashanthi. We'll resume this discussion. Meanwhile, there's a caller, Sneha from Ohio. Let's take the caller. Hi, Sneha. Hi, Sneha. How are you doing? And you can ask your question.
Yeah, hi, this is Neha here. Actually, I have a quick question related with H4 EAD and H4 extension. It's taking a lot of time, like it's almost near to the 6 months, and a lot of people are losing job because of that. So just wanted to know, like, there is any litigation coming up related with the auto renewal rule. Due to the biometrics, it's getting delayed. Like, we are not getting any biometrics appointment, and the things are getting worse now.
Yes, it's true that there is a lot of delay with the H4 EADs and H4 extensions itself. And even after you get the extension approval and the EAD approval, they're not issuing the cards. So there are already lawsuits being filed. So you might be able to add your name in it. Even if you don't add your name in it, I think you will still benefit if something good happens with reference to these lawsuits. But AILA, American Immigration Lawyers Association, has filed a lawsuit. And I was just reading today about the update that I think by the end of this month, it is going to come for a hearing before the judge. I think they said August 26th or 27th, if I'm not mistaken. So very soon we should be hearing something, and it's not going to be bad news, because there is a legitimate reason for courts to intervene. So let's see what happens. We just have to wait and see.
Yeah, but like someone who lost a job because of that, so there will not be any substitute, right? The USCIS is not ready to give any temporary letter or temporary auto renewal. Nothing is done from their side.
That is correct. That will only be done if they'll win a lawsuit. So that's the whole purpose of the lawsuit. Asking them to take measures to ensure that either they process cases quickly, and if they're not able to process quickly, then they make other arrangements for people in this situation.
Thanks, Neha.
Okay,
Thanks for your
great.
call.
So that will be on, yeah, that will be on 26th, 25th, right? This month.
I don't know the exact date. I don't remember it. It's towards the end of the month. The hearing is going to take place before the judge. All the preliminary petitions have been filed. The actual hearing date is towards the end of this month. That's the update on the H4 litigation right now.
Thanks for the call, Neha. So yeah, going back to what Neha said, there are few lawsuits that have been in progress by a lot of organizations as well as individual lawyers, especially on presidential proclamation regarding travel bans. Do you have any updates on them, Prashanthi?
As I said just now, I gave you an update on H4s. With reference to all the other, see, the interesting thing is we are seeing updates in the form of Department of State exceptions. Exactly. So these are all due to the lawsuit. If no one forced their hand, they wouldn't do anything. So pretty much now the exceptions are so broad that most people will qualify. So
True.
They're making it so that the lawsuit will become meaningless at some point. I think they'll go on adding exemptions. So that's the best update that we can get with reference to these lawsuits. What's happening, how the government is reacting to it. And right now they're reacting positively. They're seeing, they're seeing the fact that, the proclamation is over broad and overreaching and not needed at this point of time. And the Department of State, USCIS is taking further action and, with these exceptions. So we hope to see more moving forward.
Yeah, going back to our previous conversation, you were telling about the H4 aging out kids, as they are being separated or they cannot enter US. Or, can you explain more about it?
Yeah, so in order to qualify for a H4 dependent child, you have to meet the requirements or definition of a child. And the definition of a child is basically a child who is under 21. So not only does he have to be your biological or adopted child, but also that person has to be under 21. If they are not under 21, then they age out. So they're no longer qualified for a H4 visa. And then what happens is they have to find their own independent status. So if someone is going to be over 21 and needs to come into the country, they can ask for an emergency visa so that they can enter legally on a H4. And once they come into because after that they cannot enter on a H4. So, and they don't qualify. So once they come in, they can always apply for an F1 or, obviously they would want to go to school. So once they come in on a H4, then they can apply for a change of status from H4 to an F1 or whatever it might be. So yeah, that exemption is there. And that exemption is also there for aging out immigrant visas. So if you're filing for a family-based petition, more important, because if you're not able to come with your, if you're not able to arrive with your parents, then you come under a completely different category, and then it takes several years to get approval again. So it's very important that aging out children should get emergency visas so that they can immigrate with their parents.
Yeah, that's true. And apart from that, there are a lot of rumors that going on that there will be a possible second round of H-1B lottery for the fiscal year 2021 because of a lot of decline in the applications because of COVID and other reasons. So do you have any idea that there could be a possibility of H-1B lottery again and few people getting lucky again?
Well, we heard some rumors that by next week we would hear that information and that the visa numbers, the H-1B lottery should open up, but they're only rumors. I don't know what the source is, but we have not heard anything from AILA. We have not heard anything from USCIS. So we should wait until we hear something from them. But people which maybe they have intimate knowledge of what's happening behind the scenes. But for now, it would be great if they open up the H-1B numbers again And they should, because as we know, due to COVID, a lot of H1s were not filed. And the fact that they were not filed, we are able to track that in real time because, as of March 20th, we know that they haven't been filed. And it's very easy to track that. AILA has done a survey with reference to how many people have not actually, how many employees have registered, gotten picked, but have not actually filed. So, they're doing work also on that front. So let's see what happens.
So let's say if there is going to be another round of lottery, how is it going to be? Like people who are already in line, I mean, who have already registered, are they going to be selected, or it's going to be again a new registration process? And
I mean, yeah, I would think that there's the wait list that has been established, right? The wait list is based on people who have already applied before March 20th and were not picked. So they have to be prioritized first. And then if there's still more numbers, then they can take in new applications. But I think right now it'll only be people who have applied before March 20th and their cases were not picked.
Sounds good. So let's hope that there should be a second round of lottery where a lot of people can again get picked. Okay. So apart from this, there are few questions from callers offline on our social media. So I would like to ask a couple of questions regarding that. One question everyone is asking is, because of this COVID, a lot of people got stuck in India and people are unable to come back to US. But then employers are willing to give them work and let them work from India and still get paid in US and not lose the job. So do immigration laws apply when you are out of the country? Are they not? Or how is this going to work?
So you can work. I mean, yes, immigration laws don't apply if you're out of the country. So from the immigration standpoint, you have no issue working remotely or working out, from India for your employer. The only issues that will occur are tax issues, IRS issues. How will your employer pay you? Can your employer pay you in the US if you're not in the US? Can you get paid in India? Where do you file your tax return? How will the employer pay you in India? Because they are not filing taxes or payroll taxes in India. So these are questions that have to be answered by an accountant, and I think you should take the advice of an accountant to answer all these questions. And from the immigration standpoint, there is no issue with working from India, and there is no time limit as to how long you can work.
Okay, got it. So immigration has nothing to do when you're out of country, but then the local tax rules apply. So you have to talk with the CPA in US and CA in India and find out, how you have to get your salary. So another question we have is, the president's EO, executive order, especially the one that is expected in the August first week or second week, as said by President, there will be a merit-based immigration along with some relief to DACA towards a path to citizenship. We don't have any update on that yet, but then do you think something cooking or anything that's going to help?
It's hard to say, Ranjit, that what will happen moving forward, what new executive orders we can expect. President Trump has talked about merit-based immigration many times, but he has said that in the context of a bill. He wanted to sponsor a bill, with merit-based immigration, change to the way immigration is done in this country. So basically, he wants to do away completely with family-based immigration and only have merit-based immigration, which means that it's same as a Canadian and Australian system, whereby you get a point-wise, 1 point if you have a relative in the US, a certain number of points if you have a job offer. So he wants to move to that system and do away with everything else, with the H1, the J1s, L1s, all this, the other employment-based and other family-based immigration, like spouses applying for their US citizen spouses applying for their husband or wife, husbands or wives family-based, such as applying for children, permanent residents applying for their children or spouses. So he wants to do away with all this integrate immigration system that we presently have, and that's what is comprehensive immigration reform. Basically, that's what it is. That's the whole talk of, this year and last year. Everybody's been talking about how broken the immigration system is. So he's trying to simplify it, but it cannot be done, I think, in an executive order. It has to be done via a bill through Congress. So let's see what happens. Elections will say everything, and depending on who wins the election, that will also, we can expect pro-immigration reform or more restrictions on immigration based on who is elected. So that's something to wait and watch. The elections are a big game changer.
Yeah, true. And other question everyone has is, as recently USCIS revised the fees and which will be effective going October 1st. Apart from that, there is some change in terms of the premium process adjudication. Earlier it was 15 calendar days, and now I was hearing and a lot of people talking about it. It's going to be 15 business days instead of the calendar days. Do you have any update, or how is this going to work?
No, I've not heard that that it is 15 business days. So that will really increase the processing time by a week then, if that happens. I won't be surprised though if they say that, because of the layoffs in USCIS, the imminent layoffs as of the end of this month, pretty much 7,000 employees, which is 75% of the staff, will be laid off unless there is some action by Congress, and nothing has happened yet. So, I don't even know if premium processing will exist. So everything is just up in the air right now. With reference to the change from business days to calendar days, I haven't heard that. So, as long as there is no rule that is published, then it will still be the same. If there are any changes, of course, we will let the viewers know.
Sure. There is also a lot of increase in fees in terms of, especially for, I believe, the green card process and all. Could you please shed some light on that again?
Yeah, so the green card process is basically there is an increase in fee with reference to the filing of 485s, in the sense that it's very deceptive, because they've actually decreased the fee for filing the 485 by a few dollars, but they've increased it quite a lot, because earlier, if you filed EAD and an advance parole along with your 485 application, you didn't have to pay any fee for the EAD and the advance parole. Now you have to pay a separate fee for the EAD and advance parole, and therefore the 485 package fee on the whole has gone up quite a lot. So that is a change with reference to the 485 fees. It's deceptive at first. You think it hasn't gone up. In fact, they've reduced it, but actually it's gone up significantly. And also citizenship, which I'm very disappointed with, because citizenship is something that usually they keep the fee low because they want people to become citizens if they qualify, because of so that they can vote. And usually politicians want to increase the voter base, so it's a little surprising that they've increased the fee for naturalization as well.
True. Before going into another question, I would like to tell the viewers that if you want to reach out to Prashanthi Reddy Garu and have a private consultation, please reach her at 212-354-1010 or prashanthi@reddyesq.com. And also, I would like to repeat the disclaimer. Please note that this show is not intended to provide any legal advice, and it is very general in nature. Please use at your own risk. So coming back to other question, a lot of people have is between this I-140. So nowadays, PERM and I-140 are taking too longer because of the USCIS delays, especially the Department of Labor. They are adjudicating PERM applications very late. And because of this, a lot of people who are maxing out are in trouble. So are there any provisions which I heard are like, if the PERM is pending for a year, you could get an extension for a year, or if I-140 is pending, you could get an extension, or any other that could help the employee stay in US when PERM or I-140 is pending for a longer time?
So basically, as just to back up a little bit for those viewers who don't know, H-1B has a maximum of 6 years. And in order to go beyond 6 years, in order to get an extension beyond 6 years, there are a couple of ways of doing it. One is if your labor certification has been pending for more than 365 days, then you can get a further extension of 1 year on your H-1. The second way is if your I-140 is already approved, then you can get an extension for 3 years. So with reference to the first point, the labor certification should have been pending, or the labor certification may have been approved, but an I-140 may not have yet been filed, but it is within the filing period. Or it could be that the I-140 is filed, but it is still pending because maybe premium processing is not available. Whatever the reason might be, if the process from the time that the labor cert was filed, if it has been more than 1 year, and the process is still continuing, whether it be the I-140 process or whatever it might be, you can still get a H-1 extension for 1 year. Otherwise, if the I-140 is already approved, you get an extension for 3 years. This will apply no matter who has filed the labor or the I-140. It could be any employer. It doesn't have to be the employer that holds your H-1.
Okay, sounds good. Another thing, is if 6 years is maxing out, you have to stay out of country for a year, and then you have to go through lottery again. Is that true?
Yeah, so that's another way of getting, if your H-1 6 years is over, then another way, if you have not filed your green card or you have not filed it on time, you have to leave the country. So and also before that, another way, Ranjit, is to file for unused time. So basically, if you have, out of the last 6 years on your H-1, if you have spent a year, say, in India or outside the country on vacation, if you've spent a month every year, you can recapture that period. So you can file a further extension perhaps for another 6 months with all the recapture time, all the time that you have spent outside the country. Right from a few days can be counted to months or whatever it might be. Make a chart and they will allow you to recapture that time, and you can get an extension possibly for another 6 months. And this will give you additional time to for your labor to get approved or I-140 to get approved. So that's another useful tool to have. And or you can file for a change of status. If your H-1 is maxing out 6 years, you could perhaps change to an F-1, right? And then you wait for your I-140 to get approved, or labor, whatever it is that you qualify for, and then again file for a change of status from F-1 to H-1. Or it could be a change of status from H-1 to B-2, visitor's visa. Stay in the country, wait it out, and then again file a change of status once you qualify. Or as you just said, Ranjit, you can leave the country, wait for the I-140 to get approved, and then come back into the country for a further extension beyond the 6 years. Or if you have not filed any of these things, like you said, you could then just stay out of the country for a year, but then you will not be cap exempt anymore. You will be cap subject. So you'll have to wait for the next cap, and you'll have to file your H-1 under the cap if you get picked in the lottery, and then you'll get an additional 6 years. So that's possible as well.
So here there is kind of a gray area, I believe. Is it mandatory that you have to stay out of country for a year, or you could go to another visa, let's say from H-1B to H-4 or F-1 or any other visa for a year, and then apply for the cap subject petition again being in the country, or you should mandatorily leave out of the country and stay for a period out of the country? Is there something like that?
So Ranjit, it's not a gray area. Regulation does say that you have to leave the country in order to get that additional 6 years. You have to leave the country and be out of the country for a year. So you cannot remain in the country and file for a change of status. But that doesn't mean that you can't intermittently come back into the US in that last, in that 1 year period. You can come for short periods on your visitor's visa or, on your B1 just to take care of whatever it might be. You might be still working for a US employer and you need to have meetings with that employer, or you need to meet the client, whatever it might be. That's still possible. It doesn't have to be that you physically have to stay out for that entire period of time. You can come and go, but in general, yes, you have to leave the country and you have to be out of the country for a majority period of the time during that. You can only come for visits, brief visits. That will not break the period, but otherwise, yeah, you have to be out of the country.
We'll resume the discussion again. We have a caller, Suma, online. Hi, Suma, how are you doing? Welcome to the show, and you can ask your question, and attorney will be glad to answer.
Sure. Thank you so much for giving me an opportunity. I have applied for my H4 and H4 EAD in the month of April, end of April. So I was just talking to the USCIS team, and they said it will take around 9.5 months for my EAD to get approved and almost 4.5 months for my H4 to get approved. So what is the situation? And at the same time, I heard within 3 weeks or 4 weeks, it will be approved. So I'm not sure what is going on. So I thought I will check with the attorney on that. So is there any update on that, ma'am?
Right. So the only thing I can tell you is that, yes, processing times have increased, but I have not heard specifically that it is 9 months or 8 months. The only issue now is with H4. I mean, if you need biometrics, then of course you're out of luck because there are no biometrics offices open. But if it's an extension, as you know, they have made an exception and they can use the biometrics from your previous submission, so they don't need biometrics. But I think the delay is also in issuing EAD cards even after you get the approval. But your situation is that you haven't received the approval, correct?
No, not yet received.
So there is another way also, and you should not hesitate to file a lawsuit. And then you can just file a simple Mandamus case. A Mandamus case is forcing the USCIS to give a decision in a timely manner based on their processing times. And this is a very simple lawsuit to file, and individuals can file it. And I encourage, especially people who are on H4 who are losing their jobs. I don't know why they hesitate so much in doing this. This can only help you, and it won't cost thousands of dollars. So I think it is worth filing it because your jobs are at stake. So I don't know why more H4s are not doing this. I would definitely advise you to do it.
What I need to do, ma'am, in order to go ahead with this process?
File a Mandamus petition in district court. So you have to find an attorney who will do that for you, and you have to file it and force them to process your case. If you want us to do it, you can contact us. We can do it as well, or find any other attorney who will do it for you.
Definitely. Can I get your number, please, so that I can personally contact you and see whatever the attorney fees and everything I can pay? And
you can see the attorney's details on the screen. You can also reach her at 212-354-1010 or Prashanthi at Reddy ESQ.com. These are all the details are being scrolled on the screen. You can have a look at it and you can contact her offline. Thanks, Suma. Thanks for the call. So yeah, a lot of people hesitate, especially people who are on non-immigrant visas, that something is going to happen because of the lawsuits. If I file something, USGS may come behind me or something. I know these are all speculations, but do you want to shed some light on this? Actually, if it really impacts or it doesn't really matter.
So there is only a positive effect by filing a lawsuit. You need not be scared. In fact, USCIS will get scared and process your case. That is what is happening time and again with these lawsuits. Over and over again, this has happened, especially in the recent past. Lawsuit seems to be the only way to force USCIS to do the job that they're supposed to do. And that's why they're taking the fee. It's a benefits organization that provides a certain benefit for a certain fee. It's very simple. If you qualify for that benefit, they have to give it to you. There are a few cases that are discretionary, but most of it, they're very straightforward indicators of who qualifies and who doesn't qualify. So really, you have to think of it that way and think of it as if, you are approaching any other organization, you've paid the fee and they have not processed your case. Immigration is no different. So if they have not processed, then what do? You go to the higher authority. right? Or you just sit and do nothing, and then who is at a loss, right? So there's no such thing that USCIS will come after you. In fact, you will only benefit from it. We have seen that when people are filing litigation for H-1B cases, denials, employers were so worried that they will come after them. In fact, after that, those employers started getting a lot less RFEs and a lot more approvals because USCIS was scared that they would litigate again, and they don't want litigation because that takes up a tremendous amount of resources for them. So they want to avoid it at all costs. So yes, Ranjit, to answer your question, I highly encourage people to litigate now and not just sit back and take faith as it comes, but take proactive measures to ensure that you're able to work, or you're able to stay in status, and you take care of your needs and your family.
Nice. Yeah, another question we have is, if USCIS is not going to get funding by end of the August, they are going to furlough, I think, about 13,000 or something employees. So if that happens, how is this going to affect all the immigration, especially the extensions, renewals, premium or whatnot? So is there going to be a huge impact on applicants as well?
Yeah, so if that happens, then I think immigration will come to a standstill because that is 75% of their staff. So no applications will be processed. So right now what is happening with reference to that is the reason they're not giving them the funding is that they want them, USCIS, to be accountable for the money that they're taking. They want USCIS to be accountable for the way they spent the money earlier. USCIS has always received, it is based on fee. They don't get money from the government. It's based on
self-funded,
the
right?
fee.
They are self-funded.
They're self-funded, yes.
Like
They're
USPS.
self-funded, correct. So the amount of fee increase that they have done so many times over the years, and the amount and the bad processing times that they have put forth, despite the fee increase. So they have to be accountable for this. They can't keep asking for money and not improve their performance. So that is what the Congress is saying. That is what AILA is saying, that they need to be accountable. This is the best time to make them accountable for the money they're taking and how they spend their money. And for example, I'll give you an example. What happened is, with reference to EADs, production of EADs and production of green cards, even after the cases were getting approved, after COVID, just before COVID, they fired all the contractors that produce these cards, and they didn't bother to rehire. And then COVID happened, and they're not still rehiring contractors. So we don't know why they're not doing it. So it's just a blatant misuse of the resources that they have. And this, because of this, I think there is some delay in, them getting funding. But I believe even if they don't get funding, they're okay until the end of the year. That's what they have said in our latest news report.
Okay, let's see what happens with the USCIS and the funding, and what are the things that's going to happen. Coming back to another question we have is the 6-year max out thing. Do the employer or employee the perm has to be initiated within that 6 years, or let's say after 6 years is almost maxed out, and after that, let's say the employer files the perm or labor, and then followed by 140, and then will there be cap exempt, or the labor should have been filed before the 6 years is maxed out?
So if they're not looking to get a fresh 6 years on their H1 by leaving the country for a year and coming back, they are still cap exempt. So for example, if they even if they leave the country and they come back once the I-140 is approved, they are still cap exempt. But if they leave the country and they're asking for an additional 6 years on their H1, then they're not cap exempt. Then they're subject to the cap. So it all depends on what they're requesting. If they're requesting a fresh 6 years, then they're subject to the cap. They are not requesting a fresh 6 years, but they're requesting an extension based on an I-140 approval, then they're not subject to the cap.
Okay, got it. So doesn't matter when the perm or labor is filed within 6 years or after 6 years of the max out. Once they have an I-140 approval in hand, they can always use the previous H-1B as a cap exempt and come back because they have an
Correct.
I-140 approval in hand.
Correct.
Okay, that's good to hear. And another question we have from a lot of callers is, there is, I think about a couple of years back, they said that once you have an I-140 approval from an employer and it's active for 180 days, then you will be able to use the priority date as well, and you don't lose priority date, and your I-140 will remain intact. So what happens, let's say if an I-140 is approved with an employer and they withdraw it before 180 days, so they can't port the priority date, or what happens with respect to the H-1B extensions beyond 6-year period if it's withdrawn before 180 days of the approval?
So that's often people who call me, my clients, or just people who are calling for advice, get confused about this fact, about the 180 days rule. There is only one 180-day rule. The 180-day rule, basically, as per AC 21, the Act, says that if you have a 485 filed and it has been 180 days since the filing of that 485, then even if your I-140 gets withdrawn, you can still continue your green card process by porting your green card process to another employer by filing a 485 GA form. So that is the 180-day rule. Now, the other 180-day rule with reference to the I-140 is only in extreme situations. It really doesn't work. So there is something under the regulation which says that if the I-140 has been approved for more than 180 days and under certain circumstances, and I forget what those circumstances are, but they're very limited, then you can still file a 485 even if that employer is no longer there or the I-140 has been withdrawn. But the circumstances are extremely limited, so limited that that is not used. That part of the regulation is never used. But what is useful with reference to, again, AC 21 and the I-140 issue is that they have said that even if the I-140 is withdrawn by the employer, you can't file a green card based on that I-140, but you can use it. You can use the priority date of that I-140 to file another green card, another labor cert and I-140. So the priority date is not affected even if the I-140 is withdrawn. Second thing is, even if the I-140 is withdrawn, you can still file for a H-1 extension beyond 6 years. So these are two very important exceptions that AC 21 has made with reference to I-140s. And they have said that even if it's withdrawn, two things: priority date can still be retained. Second, H-1 6-year extension can still be filed beyond 6 years.
So once I-140 is approved with any employer, you get unlimited H-1B extensions, no matter what. Even if you change the employer
That's correct.
the I-140,
That's
so
correct.
it doesn't matter.
The only exception to that, Ranjit, is if the USCIS revokes the I-140 for fraud.
Okay. Fraud
Then,
from the employer or any other reasons?
Yeah, fraud-related grounds is the only exception where, your I-140 is gone.
Okay, got it. So yeah, once again, I would like to, tell you guys that, if you want to reach the attorney for private consultations, please reach her at 212-354-1010 or Prashanthi at Reddy ESQ.com. So yeah, I think we are at the end of the show. So we will come next week with again new updates. Thanks for all the calls and watching the show, guys. It was a great session with interesting topics and questions. Please call in every Wednesday at 6 p.m. Eastern Time to watch the Immigration Talk Show. Again, it's every Wednesday, 6 p.m. Eastern Time on Sakshi TV. This is Ranjit signing off. Thanks, madam. Thanks for your time.
Thank you.